Just to introduce myself, my name is Lorianne Shainstead. I am an attorney at Rathbun, Cervenek and Kozel. And today we're just going to be doing a quick presentation on preventing sexual harassment in the workplace. And this is important because there are very significant impacts of sexual harassment. And as a result, the Illinois Attorney General has come out with certain statutory provisions that all employers need to align with, because the General Assembly has found that the tolerance of sexual harassment has a detrimental influence in workplaces by creating a hostile work environment for all employees. It reduces productivity, and it also increases the legal liability. And importantly, it has lasting effects for individuals, the employer, and the community as a whole. And this can include psychological trauma and stress-induced symptoms for the victim, hostile work environment for employees. It can damage the reputation, and it also has negative publicity, can create civil liability, and possibly even lead to criminal charges, depending on the severity. So as a result, the chamber and all employees or all employers across Illinois cannot take sexual harassment lightly. There's a couple noteworthy federal laws in place because sexual harassment has been recognized in federal and state legislation, as well as court rulings throughout the country, as a form of discrimination. Therefore, it is illegal. So two pieces of legislation are Title VII of the Civil Rights Act of 1964, which prohibits employers from discriminating against employees on the basis of sex, race, color, national origin, and religion. And Title VII generally applies to employers with 15 or more employees. Then we also have the Equal Pay Act of 1963, and this protects men and women from sex-based wage discrimination in the payment of wages or benefits who perform substantially equal work in the same establishment. Now, turning to Illinois laws, one of the most important ones is the Illinois Human Rights Act, and this prohibits sexual harassment in employment and provides that it is a civil rights violation for any employer, employee, agent of an employer, employment agency, or labor organization to engage in sexual harassment. And the Illinois Human Rights Act is in line with the Illinois Department of Human Rights. So this is one of their roles to investigate charges, which they also call formal complaints of discrimination. And this includes allegations of sexual harassment in employment as well. One of the recent changes to the Illinois Human Rights Act is previously a charge had to be filed with the IDHR within 180 days of the incident. And they recently amended it about 2 or 3 years ago to allow a charge to be filed within 300 days of the incident. So that's an important piece of information to take away from today's presentation. We also have the Illinois Workplace Transparency Act, and this expands the definition of discrimination and harassment to prohibit actual or perceived discrimination and or harassment based on the act's protected characteristics. So employers are now also allowed to require annual sexual harassment training as well to all employees, and this includes employers who even have just one employee. Now, looking at the definition of sexual harassment, the Act defines it as any unwelcome sexual advances or requests for sexual favors or any conduct of a sexual nature when submission to such conduct is made either explicitly or implicitly a term or condition of an individual's employment. Submission to or rejection of such conduct by an individual is used as the basis for employment decisions affecting that individual, such as bonuses, retirement, pension, any other type of benefit or vacation time. Or if such conduct has the purpose or effect of substantially interfering with an individual's work performance or creating an intimidating, hostile, or offensive work environment. And it's also important to note that the phrase working environment is not limited to a physical location an employee is assigned to. This can be outside events or vendors as well. There are two types of sexual harassment generally, and most people recognize quid pro quo, which means you do something for me and I'll do something for you. So this means that if a supervisor or management or someone in authority, they cannot tell a subordinate that in order for them to receive a promotion, a raise, any type of job benefit, that something negative will happen to them or something will be taken away or a discipline. And then the other type of sexual harassment is hostile environment. And this is typically when unwelcome sexual advances, requests for sexual favors, or any conduct of a sexual nature has the purpose of substantially interfering with an individual's work performance, or if it creates an intimidating, hostile, or offensive work environment. Turning to quid pro quo harassment, the first one that we talked about, it means this for that. So something is given or withheld in exchange for something else. So this is not the most common form of sexual harassment, but this is the one that most people think of because it is a tangible item or perhaps a monetary loss or job, something to do with benefits, reduced vacation time, a change in a preferred work assignment or location. And it typically exists when there is a power imbalance between the two parties. So for example, a supervisor tells a subordinate that he'll schedule him or her on a better shift if he or she will go on a date with him. And the second form in hostile work environment is the unwanted sexual or gender-based behavior creates the intimidating, hostile, or offensive work environment that substantially interferes with a person's employment. So a common example is sending offensive emails or text messages. And even though some might perceive the content as humorous, it's still considered hostile if it offends the person receiving it or a passerby or a witness to that incident. There's a couple different similarities between the quid pro quo and hostile environment harassment. It can occur at all levels of the organization. It can include administrators, supervisors, coworkers, vendors, or contractors. Both are equally illegal, and both require the employer to take action to prevent, investigate, and remediate these types of harassment. And it's also important to note that the gender of the harasser and victim do not make any difference under Illinois or federal law. Turning to offensive or unwelcome behaviors, sexual conduct becomes sexual harassment when the behavior is unwelcome. It can be unwelcome in the sense that the victim did not solicit it or invite it, or in the sense that the victim regarded the conduct as undesirable or offensive. And this is important when looking at jokes or things that people don't necessarily intend to come off as harassing. It depends on the individual receiving it. And consent can also be revoked at any time. So when someone is experiencing sexual harassment behavior and says, stop talking to me like this, or please stop, or I'm offended, or I'm uncomfortable, it must stop. The perpetrator cannot use it as a defense of, well, you started it, or you were okay at first, or well, you were laughing originally. Once the individual is uncomfortable, the jokes or comments need to stop. And the next couple slides will focus on the types of behaviors that can be considered sexual harassment. The first is verbal, and then nonverbal, and followed by physical. And a couple examples of verbal sexual harassment are threats or bribes for unwanted sexual activity, sexual or derogatory comments and innuendos, jokes or rumors that are sexually oriented, suggestive sounds, offensive graffiti, spreading rumors or gossip, letters, notes, telephone calls, or other materials of a sexual nature. This includes emails, text messages, videos, posts on social media, deliberate touching or leaning over. This is an example of cornering someone into a wall so that they can't move, they feel trapped. And then we also have nonverbal types of sexual harassment that includes ogling or leering, pointing, winking, other types of sexually suggestive gestures, facial expressions, or bodily movements, and humiliating or degrading images of a sexual nature, including clandestine or altered digital photos or video clips as well. And lastly, we have the physical sexual harassment, which can include touching, groping, patting, tickling someone, brushing up against someone, snapping a female's bra, pulling down someone's pants or shorts, reaching under a skirt. And these all seem like very obvious situations, but unfortunately, these do occur, and victims do need to know how to bring forth a complaint, and employers need to be mindful that they need to properly investigate and prevent these types of things in the workplace. And then another important point to note is that gender identity and sexual orientation do not matter. A person can be the victim of sexual harassment regardless of the victim's gender identity or the perpetrator's gender identity. And this is the same for sexual orientation as well. And one thing that people don't always think about is that an employee's working environment is not just the physical location where the employee is assigned. An employee's working environment can extend to other office locations and remote, offsite, or moving work locations, such as events or other offsite events as well. And it's not just limited to coworkers and supervisors. Sexual harassment in a working environment can extend to patrons, vendors, and delivery people who come into the workplace and interact with employees. So those non-employees can also violate sexual harassment laws and policies, and they can be victims as well of sexual harassment. The Illinois Human Rights Act does protect customers and patrons from sexual harassment in places of public accommodation. So these are hotels, stores, museums, shops, hospitals, and restaurants in the area. And employers that are also places of public accommodation are too responsible for sexual harassment of their customers and patrons when it's perpetrated by their employees or non-employees. So they can't just take the bury their head in the sand approach. They do have to take action and properly investigate to ensure that everyone is protected. Now, turning to the role of the courts for sexual harassment, courts determine whether a work environment is hostile or abusive by looking at all of the circumstances. So one of the phrases people might hear is the totality of the circumstances. So this includes the frequency and severity of the conduct, whether it is physically threatening or humiliating, and whether it unreasonably interferes with an employee's work performance. Courts also consider the reaction of a reasonable person in the victim's position. So neither a very prim or sensitive person, but also not one for whom anything goes and nothing offends them at all. A single severe incident can also constitute sexual harassment, such as groping a staff member, or some type of one-time physical conduct can be enough to create hostile or abusive environment. If the conduct is less extreme, though, such as an inappropriate joke, then that, for example, the courts can require the victim to show a pattern of repeated, routine, or generalized harassment. And other factors that the courts typically consider are whether the conduct was verbal, physical, or both, whether the alleged harasser was a coworker or supervisor, whether others joined in on the harassment and it was done publicly with, perhaps the intent to embarrass, or whether the harassment was directed at more than one individual. So as an example, if one person was specifically targeted, or if the comment was made generally to a group of people. And there's a couple different types of judgments or court consequences that can happen. This can include job reinstatement, back pay and benefits the victim should have earned, compensatory damages, so these are just damages for out-of-pocket expenses, or punitive damages, which are intended to punish. And then in sex-based wage discrimination, these can be liquidated damages as well, which would be equal to the amount of back pay awarded to the victim. And another important point is that retaliation is also in line with prohibition for sexual harassment. Employers cannot retaliate on someone who participated in an investigation, made a good faith effort to report, or served as any type of a witness. And retaliation is defined as adverse action So this can include demotion, discipline, termination, salary reduction, a negative performance review, or a change in job duty or shift assignment, or a change in job location. And there are certain anti-discrimination laws regarding retaliation that also prohibit employers from taking adverse action. A lot of people recognize the Illinois Whistleblowers Act, but also under the Illinois Human Rights Act, it is a civil rights violation to retaliate against someone who has opposed that which he or she reasonably and in good faith believes to be unlawful sexual harassment and employment. So when an employee complains of sexual harassment to a supervisor or a department head, coworkers, other people in the business, or to a government agency such as the EEOC or the Department of Human Rights, action cannot be taken against the employee that the employee could view as punishment or retaliation. And to succeed in a retaliation claim, an employee has to meet all of the following. First, that he or she engaged in a protected activity, such as complaining of sexual harassment or participating in an investigation. That he or she suffered an adverse employment action, such as a demotion, termination, change in benefits, loss of vacation time, and that the protected activity and the adverse action are linked. So whether you're the employer or the employee, it is always important to document because these need to be linked in order to prove or disprove retaliation. And the next couple slides deal with reporting sexual harassment because they can be reported through the Illinois Department of Human Rights or the Equal Employment Opportunity Commission. And the choice of how to report is a personal one and depends on a couple different factors you might want to pursue. So first, you can always call the State of Illinois Sexual Harassment and Discrimination Helpline, and the number and website is listed here. And there are helpline representatives that can help callers navigate their various options, and they can also provide additional information and forms as well. And if you are comfortable or not comfortable calling the hotline or the helpline, you can also report the incident to your supervisor or a department head. The chamber policy specifically states a supervisor or a board member. And these are the various IDHR offices. They, depending on your location, you may want to call one or all or different ones, whichever one you're closest to. And just to differentiate between the IDHR and the EEOC is federal, so I'll get to those slides in a little bit, but the IDHR is the state agency responsible for enforcing the act. And complainants, who are typically the victims, they may file a charge at any time within 300 days of the incident. To start that process, the complainants make they fill out the information sheet to the IDHR. And after the IDHR completes its investigation, then either the person can file a lawsuit in civil court, or they can file a complaint with the Illinois Human Rights Commission if the IDHR found that substantial evidence of a violation exists. And now looking at the EEOC, it's a bit different information, but here is the number and the website. And there is a Chicago district office as well as a St. Louis district office. And the EEOC is different because they enforce the federal law, which is Title VII, which makes it illegal to engage in sexual harassment or retaliation. Like the Illinois law, they can file a charge at any time within 300 days of the incident. And the EEOC has jurisdiction to investigate employers who have 15 or more employees, because Title VII is applicable to employers with 15 or more employees. So to start that process, one can call the EEOC or visit their website that I previously listed. And after the EEOC completes its investigation, the complainant can file a lawsuit in federal court, which is different than the IDHR, that is state-based. And the EEOC can also help parties reach a settlement through an informal process they provide if they find that reasonable cause exists to believe that discrimination occurred. And one thing that's very important to note is false reports are also prohibited. Allegations of sexual harassment are very serious and can have a significant impact and therefore employees cannot knowingly bring false accusations of harassment. If it is determined that an employee did make an allegation of harassment that he or she knew to be false, then disciplinary action up to and including termination can result for that employee who made the false or the bad faith allegations. And the last couple slides focus on employer liability because with manager or supervisor harassment, employers are strictly liable for the harassment perpetrated by its members of management, regardless of whether the employer knew of it. They do have to take action and make sure that they thoroughly investigate. Regarding coworker and non-employee harassment, employers are liable for harassment perpetrated by an employee, coworker, or vendors only if the employer knew or reasonably should have known of the harassment and failed to take corrective action. So again, employers cannot bury their head in the sand. They do have to be aware if they reasonably should have known of the harassment and then they failed to take prompt and corrective action. Turning specifically to the chamber policy, and also in line with the Illinois Department of Human Rights Act and their statutes, if you are comfortable, communicate directly with the offender and express your objection and that the conduct is unwelcome and offensive. Now, this is oftentimes very difficult for a victim to do in confronting their abuser, or that's not something that is always readily available. So as a result, whether you're the employer or the employee, document each incident of the alleged harassment, put the date, the time, the place, who said what, surrounding circumstances, anyone who may have witnessed the behavior, what the context was, things like that. And then immediately bring the attention to your supervisor. If the supervisor is the source of the problem or condones the problem, then contact the next level or any member of the chamber's board of directors. And the chamber will subsequently investigate the complaint as promptly and thoroughly as possible, and all complaints will be kept confidential to the extent possible. And just to outline a little bit of the investigation, once the supervisor is notified of the complaint, then the following actions take place. We have first, they will immediately respond to the complaint and initiate an inquiry or an investigation. They will then interview the victim and take reasonable action to prevent that person from any retaliation or experiencing further harassment. They will also interview all the relevant witnesses and then interview the alleged perpetrator of the harassment. And throughout this process, everyone will make sure to document the investigation results and maintain the file as an employment record and keep it confidential to the extent possible. And then depending on the findings, then corrective action will be taken as appropriate. This can include suspension and up to termination of that person's employment. A couple different action steps to develop a no tolerance culture in your workplace is to always make sure to educate yourself and others on the signs of harassment. So that way, even if you're not the victim yourself, you can recognize if someone else is experiencing this type of harassment, and to be able to speak up to harassers if you are comfortable or feel comfortable speaking to a supervisor or a board member to rectify the behavior to make sure that it stops. It's also important to cooperate in investigations, including if you're a witness, and whether you are the victim or the witness, to try and maintain confidentiality to the extent possible to protect all parties, including yourself. And the chamber has a sexual harassment policy, so I would encourage all employees, as well as any other employees or employers watching this, to make sure that you read your policy, you understand it, and that it's as up to date as possible. And a couple different takeaways are, again, review your policy in the employee handbook. Remember that intentions do not matter if a person feels harassed. Different people can have different reactions to the same behavior and different interpretations. So if you are in a group setting and you know that everyone's comfortable with your jokes, be mindful that there could be witnesses or passerbys walking by you that could be offended by your behavior and don't know the intent of any good-hearted or good-natured joke that you may think you are saying. And finally, harassment can be from an employee or non-employee, including vendors. So going forward, if you encounter any form of sexual harassment from anyone, The problem should be brought to your supervisor or chamber board member. All complaints will be kept strictly confidential to the extent possible. And then if you have any questions going forward, please direct them to the chamber president. And lastly, you do have the right at any time to contact the Illinois Department of Human Rights or the EEOC if you so choose. And this is their address, and then their specific contact information is in the previous slides.